Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court is
Thank you. Please be seated. We turn to the third case on this morning's docket. That is case number 104475, State of Kansas, Appellee v. Cody Breeden, appellant.
Good morning. May it please the court. My name is Matthew James Edge of the Kansas Appellate Defender Office, and I represent Mr. Cody Breeden. With the Chief Justice's permission, I would like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you, Your Honor. What I would like to do is submit issue number 3 on the brief and number 5 as well. And note that the state has conceded issue number 5 regarding lifetime post-release, and then talk about issues 1, 2, and 4. Begin with issue number 1. We're asking for a lesser included offense instruction on attempt. And I think this kind of issue breaks down into 2 parts. First is to see whether or not it was error not to give the instruction. And then secondly, in cases where the instruction has not been requested, there's an additional step to see whether or not it's clearly erroneous. And a reversal can only be given if it's clearly erroneous. But I think as far as the first step, viewed in the light most favorable to the defendant, we can see that it was erroneous not to give an attempt instruction. There was conflicting testimony regarding whether or not the victim had completely disrobed, and whether or not he had taken off his
wasn't that defeated by your client's statement about his conduct during the act, or what during that evening? Didn't he state that he had oral contact with the victim in his statement?
He made a statement to police. That's correct, Your Honor. However, I mean, the jurors can believe that there are such things as false confessions, and that a person who's being interrogated by the police and may have done something clearly wrong,
was that even suggested in this case, a false confession, or that there were circumstances that could lead to that, kind of the oppressive and custodial circumstance? Was that even remotely suggested to the jury?
Well, Your Honor, I don't think it has to be the result of an oppressive atmosphere in a custodial interrogation.
Well, that's typically how false confessions happen.
Look, Your Honor, we instruct jurors that they are allowed to rely on their everyday experience in evaluating the evidence before them. And I think that encounters with law enforcement officials are a fairly common thing that jurors may use. Now, obviously, we ask them questions about that during voir dire, but it's not automatically a disqualifying thing to have had prior contact with the police.
Isn't the issue or the element involved is that there's a failure to complete the act? The fact that someone may have falsely confessed doesn't mean that that's evidence of a failure to complete the act. Attempt is you started but didn't complete. And what evidence in the record was there that he tried but didn't complete?
There was evidence that the victim did not take off his underwear.
Is skin-to-skin contact required?
I think you're assuming that by the underwear argument.
What's that?
I think you're assuming it is by your underwear argument.
I'm not exactly sure whether the statute says contact or penetration. In any event,
Kind of touching.
I think the fact that even if he's wearing underwear, a jury can assume from that the contact did not actually take place, because no one. I mean, presumably. The perpetrator of the crime would attempt to completely disrobe a victim instead of partially before beginning the contact.
I don't know that that's required, though.
It's not required. I mean, the question isn't a sufficiency argument, and I think
that point
would defeat a sufficiency argument.
Is it so much that there is evidence that he didn't completely disrobe, as there is one witness who says, "I don't know," and then the victim saying, "No, all I was wearing was a T-shirt and pajama pants." So there's some positive evidence that he wasn't wearing underwear, and then the eyewitness Leslie just saying, "I don't know," kind of evidence.
And that leaves open the possibility, which I think is sufficient. And I mean, look,
So we instruct on every possibility? Doesn't there have to be some evidence?
Has to
Yes, I
be
mean-
a jury to reasonably convict on
but
Isn't that right?
the standard is the evidence viewed in the light most favorable to the defendant. And secondly, there's a duty to instruct even if the evidence is weak or inconclusive.
I think the next step, though, as we've said in our case law, is there has to be evidence that would lead a jury to reasonably convict on a lesser included offense.
That's correct.
So that, to me, curls back to what Justice Johnson was asking you earlier, and that is, what evidence do you have that this was, in fact, just an attempt, that a jury could use to reasonably convict on that attempt?
Right. Well, you have the uncle who viewed the defendant and the victim in positions that suggest oral sex, but he didn't say that they were actually having oral sex. So I think that suggests that they position themselves, that they're attempting to do it, but his failure to say affirmatively that that is what was happening would allow a rational fact finder to conclude that there was an attempt, but it was not completed.
Counsel, even if we assume that you're right on factually and legally appropriate, can it meet clearly erroneous? Can it meet a reversal standard?
I think so. I mean,
In view of his statement to the police?
I think that, a jury can look at like I said, juries have been in positions where they've been asked difficult questions.
But that's not the standard. Whether it could in some theoretical universe happen, that's not the standard for.
Well, I think the standard
reversal.
is that the court is firmly convinced that there is a real possibility of a different outcome. And I think that there is a real possibility of a different outcome here, even in the light of his statement. I mean, you have witnesses, for instance, to believe the prosecution's case, you have to rely on a victim who called the police, when told to call the police by his parents, hung up on the first time and was uncertain about testifying against the defendant. So, I mean, I think that jurors have the ability to weigh the credibility of witnesses, even when they're essentially giving testimony against themselves.
Explain how your constitutional argument overlays with our standard analysis of lesser included offenses. Are you suggesting that it changes the reversibility standard, or just the entire analysis, or how does that fit in with what we typically do in a lesser included offense?
To be honest, Your Honor, I think that all it really does is preserve it for federal review. Rather than making it a state instructional issue, I've implicated some federal constitutional interests. I think that even under that constitutional analysis, there's a clear error standard as well, and I think a plain error at least pretty much lines up very closely with our state standards. So my intent in including that was simply, if down the line he needs to pursue a federal habeas, I've done what I need to do to preserve it, I hope. If there are no further questions with regard to that issue, I'd like to move on to issue number 2. And here we're dealing with a limiting instruction because there was also evidence, the victim testified that Mr. Breeden had either punched him or threatened him if he told.
All at the same time or virtually contemporaneous with the sexual assault.
That's correct.
How are these prior?
Well, the statute doesn't require prior, it simply requires other, and I think that it has to extend to uncharged conduct as well.
What about the last phrase of the statute that says on another specified occasion?
Well,
That talking to a different
I think that
course of conduct?
I think that as long as it's uncharged conduct, or if it's something that could be charged and the state doesn't bring it forward, I think that we still have to do the prejudice analysis in 455, and that calls for a limiting instruction in the necessary cases.
What's the meaning of those words in the statute then? It reads, the first part, the person committed of a crime on a specified occasion is inadmissible to prove such person's disposition to commit a crime or civil wrong on the basis for an inference that the person committed another crime on another specified occasion.
That's only if you read another to exclude an event that happens contemporaneous with the charged conduct.
Hasn't the federal case law developed into an intrinsic versus extrinsic occasion analysis? Are you familiar with that?
Well, I think that if we go down that line, it tends to erode the res gestae doctrine that we developed in this court in Gunby. Suddenly, res gestae is alive again.
They've made a distinction.
Well,
I'm not sure whether I buy
if you call it intrinsic as opposed to extrinsic, I mean, at the end of the day, you're still bringing back something called res gestae. And I mean, what is the issue here is that you have conduct that the state is relieved of the burden of having to prove beyond a reasonable doubt to the jury, and the prejudice is that they're going to use that to bootstrap claims that they do need to make in order to get a conviction. And I think when the other conduct happens is sort of secondary to the kind of inherent problem that we're talking about, or that 455 is designed to address. And it was sort of why we decided to get rid of the res gestae exception for 455 analysis. So I think that being said, I mean, the state's only argument here is that this argument is not preserved due to the failure to make a contemporaneous objection to the admission of the evidence. And they cite King for that proposition. And I think that doesn't work in this particular case because this is not an argument that's directed towards the admission of that evidence. And in fact, it probably is admissible. The question is, what do we instruct the jury with respect to how to evaluate that evidence? And I think that you can still make an objection, or you can still raise this issue in the absence of a contemporaneous issue. And I would note, furthermore, that the state has not made any claim that this was not clearly erroneous of the failure to give this limiting instruction. And I see that I'm out of time, so I'll pick any further questions from the court, if there are any.
Any more questions of counsel? Thank you, counsel.
Thank you.
Good morning. I'm Jennifer Tatum, an assistant district attorney with the Wyandotte County District Attorney's Office, and I'm here on behalf of the appellee. I will also rest on our brief on issues 3 and 5 as the appellant has done. So I'll start with issue 1 in this case. Basically, the testimony we had in the case was fairly simple. We had the child, who was 10 years old at the time, testified that the defendant, Mr. Breeden, did perform oral sex on him, and he was very clear about that. We had Mr. Leslie, who was a guest at the home, who came downstairs and saw Mr. Breeden and this child in a position that suggested oral sex. He didn't know exactly what they were doing. He didn't know exactly what the victim was wearing, but he immediately went upstairs and told the child's mother that something bad was going on downstairs. And then you have the testimony of the mother who called the police. And finally, you have the defendant who told the police that he did, in fact, perform oral sex on the victim. That's basically the facts of the case. There is nothing to suggest that the defendant simply attempted to perform oral sex and failed. For those reasons, there was no reason for the judge to instruct on attempted aggravated criminal sodomy in this case. There's no real possibility that the jurors would have rendered a different verdict considering the testimony. I don't think jurors would have relied on Mr. Leslie's testimony that I couldn't really tell what they were doing over the victim and the defendant's clear testimony that oral sex took place. And for that reason, we don't believe it was an error for the court to fail to instruct on attempted aggravated criminal sodomy. With regards to issue 2, there's testimony that the defendant, and I don't ever believe it was clear, it was clear that the victim said he hit him in the stomach and then forced him to allow him to perform oral sex. And then at some point he threatened him and said, if you tell the police, I'll kill you. I don't know that it was ever clear at what point in the act the defendant made those threats, if it was before or after. At any rate, all of it happened in a very short amount of time. It all happened contemporaneously with the oral sex. And again, for that reason, I don't think a limiting instruction was necessary. I know this court has held in the past that the language of the statute is on another specified occasion, meaning at a different time. This was all contemporaneous again. And had the jurors been instructed, or had they been given a limiting instruction, again, I don't think there's a real possibility of a different verdict in this case. I don't think they would have said, we based our guilty verdict on the fact that he punched him in the stomach and threatened him, rather than the fact that he admitted that he gave oral sex to a 10-year-old child. So we don't believe that issue 2 has any legal merit. Moving on briefly to issue number 4, which is the Jessica's Law argument. I believe after the briefs were filed in this case, this court did issue an opinion. It was the Woodward opinion in 2012 that addressed some of these issues. I do think the first issue under the Freeman test is still relevant in this case, but I don't believe that the punishment is cruel and unusual, as this court has decided it. In this particular case, the judge did consider all the Freeman factors. He heard testimony at sentencing. There's testimony that this child was upset, obviously, at the time it happened. He didn't initially want to tell his mother what happened. He only told her with his face hidden in a pillow, which suggested he was experiencing some shame and fear. He was looking out the door, making sure the defendant was gone. And then we were also told at sentencing that he's had to see a therapist, and his therapist has told the mother that the real psychological effect of this won't be clear until his teenage years, although he has definitely experienced harm over it. This defendant also told the investigating detective that he had fondled another child, although he, I think, was closer in age to her at a different time in his past. So he had done an act similar to this once before. And the judge considered those factors in deciding factually that this was a case that was appropriate for a Jessica's Law sentence. And so for that reason, we'd also ask you to deny issue number 4. What about the other factors? The other factors were considered in this case. The second factor the judge considered, he found that the punishment for crimes such as rape and aggravated kidnapping were also more serious. They were punished more severely than other crimes, such as the homicide crimes the defendant mentions in his brief.
The sentence for first-degree premeditated murder without aggravating circumstances is a hard 25 life sentence. And is that subject to good time credit? I'm not certain, but anyway, the Jessica's Law is hard 25 with no good time credit, at least as severe. Mr. Breeden got at least as severe a sentence as if he had killed this child in cold blood. Is that proportional?
Judge, I think our legislature and other legislatures around the country.
Well, I understand the legislature, but we're dealing with constitutionality. Did the founders of Kansas, in Section 9 of the Bill of Rights of the Kansas Constitution, when it said cruel or unusual punishment, contemplate that a cold-blooded murderer would have the same sentence as someone that fondled a child?
Well, Your Honor, I think that in this case, a 10-year-old boy who was forced to submit to oral sex from an adult against his will, that's a serious offense. I think if you're asking me my personal opinion on it, I think it is proportional. However, I think these arguments were also made in that Woodard case to this court, and I think the court has decided the matter. I'd also add that the defendant did not raise those issues necessarily specifically in his brief with regards to first degree.
I know that all the arguments seem to be on second degree, and I've never quite understood when it's the same sentence for first degree premeditated, but I understand that's the argument normally made to second degree. Yeah.
The judge in this case also compared the punishment for this crime to that in other jurisdictions, and so he performed all of the functions he was needed to perform under the test. And Your Honor, for those reasons, Your Honors, we would ask that you affirm this conviction. Do you have any questions of me? If not, I'll stand on the brief for the remainder of the issues.
Any further questions, counsel?
This is just a practical question. It seems like we're getting a whole bunch of these lifetime post-release supervision errors, and it seems to me it's simply because the box on the printed journal entries that are used are marked. And I'm just curious, when these come up, why doesn't the state simply move for a nunc-pro-tunc in the district court? I mean, you agree that if the judge checks post-release supervision on the pre-printed journal entry and it's an off-grid crime, that's not right. Just wondering why they're just not nunc-pro-tunct as a matter of course.
Well, I guess from my perspective, just the fear that then we'd end up back here maybe on an illegal sentence. I don't know. But I could tell you that at least out of Wyandotte County, you'll see fewer and fewer of these issues coming before you. We're working on it.
Any further questions? Thank you, counsel.
Thank you.
You'd reserve 3 minutes for rebuttal.
Thank you, Your Honor. I think that I've covered pretty much everything in my first part of my argument. If the court has no further questions, I'll yield my remaining time to the court.
On issue 3, on the advice of rights, after the state pointed out the colloquy between the court and the defendant the night before the defense was presented, or the defense said, we have no witnesses, do you fault that colloquy as being insufficient? Was there something that the trial court needed to ask that the trial court didn't ask, or something?
I think that what would be required at a minimum is just that you have to explain that the defendant has to know that he has the right to testify, that he cannot be compelled to testify.
Both those things were done, isn't that correct? And
that he is willingly chosen not to do so.
And I think the court did say you have a right to testify, you have a right not to testify. What the court didn't put on the record was the final decision of the defendant. Are you faulting that?
Yes, Your Honor.
So you think that final step has to be done even if the court has given a full advice of rights?
That's correct, Your Honor.
How do you dovetail that with the Fifth Amendment right to remain silent? If the judge asks for a response on whether they testify or not, the defendant's got the right to remain silent. He doesn't have to say whether I'm going to testify or not. You've got competing rights here. You have the right to be able to testify if you choose, but you have a right to remain silent, correct?
Well, I don't see how a waiver on the record of the right to testify could be construed as incriminating, Your Honor.
Oh, I think their argument could be made. Well, he chose not to testify, and that must mean he's guilty. I mean, the whole point of the right to remain silent, you don't have to say anything.
Well, that's why
it might incriminate you. So why are we going to say you have to address the court and tell the court whether you're going to testify or not? Well, that's a choice you can make, and you choose it by exercising.
Well, Your Honor, I suppose that argument could be made, but that would run afoul of Doyle if counsel were to suggest that to the court. Also, we have an instruction that says, the defendant has chosen not to testify. So I don't know that it really creates the conflict between the with the Fifth Amendment that is contemplated here, Your Honor. If there are no further questions, I'll yield my time to the court.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. Clerk will take this matter under advisement.